about starting a business.
I'm Cade Cumby.
I'm Daniel Beam.
I'm Sam Marshall.
And I'm Sam Grusendorf.
So we'll be talking about starting a business. There's a lot of ways to start a business. We'll be talking about the advantages and disadvantages for taxes and liability. We'll talk about how to start a business and important court cases for each type of business. And then it's important to know these things to help your clients start businesses and to start your own business yourself. So first we're going to talk about S corporations. An S corporation is like a C corp and other entities as well, like partnerships and sole proprietorships. You can have 1 to 100 shareholders. These have limited liability, so you can't personally be liable for the debts of the company if you were to be sued or something. It's a pass-through entity for taxes. Like we talked about in income tax, the taxes are paid on behalf of the company on each individual's income tax return. So they'll file their own taxes. You won't be double taxed. And it's great for starting a business because you'll be able to deduct those business expenses at the beginning on your own tax returns. So in order to start an S Corp, you have to be a U.S. citizen. You can only have, like I said, 100 or less shareholders. That'll be good for PFP or financial planners because there's usually less than 100 owners of the business. It has to be a domestic business, only does business in the United States. All shareholders have equal voting rights, so me and all the rest of my owners can vote equally. And all you have to do is file forms with the IRS stating that you're going to be a pass-through entity that pays taxes on your own income tax returns. My case is about Mr. Fleischer, who is an LPL broker-dealer. When he started his business, all of his registrations were listed under his own name rather than the business's name. The IRS said that he was acting like a sole proprietorship, and S corps pay the employer portion of FICA tax, but since he was acting like a sole proprietorship, he owed self-employment tax. He ended up being sued by the IRS and owed them $42,000 in back taxes.
And general partnerships are an unincorporated association of more than one owner. Each owner is called a general partnership or general partner. They're flow-through entities like an S corp. So the partners pay taxes through their personal income tax, and the company doesn't pay taxes. It's also an unlimited liability company. So each partner can be sought after for debts of the partnership, and all the management rights are shared throughout each partnership. Starting a general partnership is pretty easy. You just need an agreement with another person to start the business. A lot of people actually end up starting general partnership without even knowing it. There's not very many forms or filings that are required unless there's a binding agreement between the partners. The partners share all the profits evenly and will pay taxes evenly on the profits. And then my case was Congo versus Malfitano. It's out of New York, and it was a general partnership of ownership of a shopping mall. And they had a binding agreement to dissolve. They couldn't dissolve the company until a certain date, and one of the partners decided to go ahead and dissolve his before that, and it was worth about $4.8 million, his share. And the other partners in the group decided to go ahead and sue him, and they were awarded $900,000 plus legal fees totaling well over $1 million. This case is still ongoing through the appeals system.
I'll be talking about sole proprietorships, and just like they sound like, it's just owned by one person. It's the most basic business formation. You're unincorporated, and it's the most popular in America. So there's no distinction between you and your business. Kind of like Sam was talking about with this S Corp case. You are the business. It's your name. So you're in charge of you have total control over it, but you also are in charge of all aspects of it. It's got a low cost to start and operate, but like I said, since it's your name, you're at a higher risk for debt repayment. And since it is easy to start up, it's really common for most individuals to start their company that way, but you still need to have all proper licensing and paperwork for whatever field you're in. So some advantages to a sole proprietorship. Like I said, there's no need to file your business. This is the case in Texas and Florida and most other states. since you and the business are the same, you don't have the small business taxes. Your taxes are just your own, so you need to file your Form 1040 and Schedule C, making it easy to prepare. And as long as you track it well, tax season isn't that hard to deal with. With more employees that you have, it gets more complicated. But with just an individual and a sole proprietorship, it's pretty straightforward and simple. You have total control of the business, so this is good and bad because you get to say, you have all say in what happens and what doesn't happen, but then also you have total liability for the business debts. So if you go under or you owe money to debtors or creditors, then they can come directly after you and get the money back. And then one other disadvantage to sole proprietorships is that you can't sell shares and raise money that way. You either have to sell the business entirely or go through all the paperwork of reclassifying it. So this makes it difficult to raise capital for the company. So my case is a little old, but it was a landmark case for sole proprietorships. Basically, this guy, Rodney Lewis, owned his own towing company, ABC Towing. And when one of his employees was at work, he poured gasoline on the ground, which violates pollution laws, both federal and the state of Alaska. So when the employee went to court, he pled guilty. Prosecution wanted to prosecute him and ABC Towing, Lewis's company, but he said that his actions weren't instructed by Lewis. He just did it on his own. So when the prosecution tried to try ABC, they couldn't because it technically isn't an organization like a franchise or an LLC. It's a sole proprietorship, so they'd have to sue Lewis. And since the actions weren't directed by Lewis, they couldn't sue him for the employee's action.
So limited liability corporation is pretty similar to a partnership. The only difference would be that the owners are not responsible or liable for the debts of the company. The LLC, they may elect to not pay federal taxes. Instead, their profits and losses are listed on their personal tax return of the owners of the company. To create an LLC, they first have to come up with a name for the company, and then they have to create an article listing the duties of each owner in the company, and then just submit it off to the state. An LLC is not suitable if the owner wants to publicly trade the company on the stock market. Also, another disadvantage of that limited liability corporation would be if a partner dies, then they have to dissolve the company because the paperwork that they submitted through the state would then be at fault. My court case is Gottsacker versus Monier. So Julie, she formed an LLC in 1998, and she purchased property for $510,000. After the property was purchased, it was appraised for $703,000. In '99, two brothers, Gregory and Paul Gottsacker, became members of her company and held 50% ownership in the company. In 2001, Gregory and Paul ceased to participate in the company's affairs, and Julie sold the company and renamed it to 2005 New Jersey LLC. Julie now owned 60% and Gottsacker owned 40%. Julie went behind their back and acted in her own interests, as well as went against the fiduciary duties of the company. In the court case, they wanted them to elaborate more on what the duties of each member had to do, and Monier failed to do this. So, yeah, just have to elaborate more clearly on the articles that are submitted to the state.
And lastly, I'll be talking about franchises. And these are usually set up as a corporation or an LLC. But a big thing here is that they must comply with the Federal Trade Commission's franchise rules. And the big rule here is that the franchisor must provide the franchise disclosure document, or FDD, to the potential purchaser before anything else can really happen. So the FDD is a lot of good material facts that are necessary for a potential purchaser to understand what they're getting into, potential liabilities and risks. the cost of buying and operating the franchise, and the history of the franchisor and any of their key executives, really. And so you see here in the bottom, the FDD is kind of the lock. So once you get the key to that, once you get your FDD, then the resource flow can start going from the franchisor to the franchisee. And the case I focused on was based between the National Labor Relations Board and McDonald's. And this was back in 2012 when McDonald's was accused of discriminating against workers who were taking part in a protest for fast food wages, workers' wages. And so the NLRB wanted McDonald's to be responsible for the actions of individual owners and in turn have to pay out to the employees what owners did. And so after many years of litigation, the NLRB and McDonald's came to a settlement in where McDonald's would still be considered a separate employer, so they wouldn't be a joint employer. But they paid out a lot of money to these employees and to current and former franchisee employees to receive for the many years of litigation that went on. And so this keeps franchises like McDonald's safe from potential risk that could be caused by one crazy owner in a McDonald's. So in conclusion, it's really important to know different types of businesses and how they work when giving advice to clients on how to start their potential business, because if it's something they've been dreaming on for a long time, if that's a dream and a big goal of theirs, you don't want to mess it up for them. And it's also important if you're setting up your own firm in the future, so that way you can get your business off the ground without any troubles. And understanding a business is super important for the tax advantages and disadvantages that come with each one. Because if you're just starting up your own little shop in your garage, you don't want to be an S Corp or a major corporation. It's probably better to be a sole proprietorship, just your name, focus on you, and any additional liabilities that can come with owning a business like that. So we just like to thank you all for listening to our presentation and hope you'll have a safe rest of the semester. Thank you.